Good morning, everybody. So today we are joined by Honorable Justice Abhay S Oka, who has recently demitted office in the Supreme Court of India as a judge of the Supreme Court of India, one of the most respected voices in the Indian judiciary, known for his fearless commitment to judicial independence, and a body of judgments which have left a lasting impression on the legal jurisprudence of the country. A judge who has never minced his words in the courtroom, and he has never held back what he feels when he is adjudicating a matter in the courtroom, irrespective of who is before him, whether it's the government of India, whether it's the senior lawyer, or a very, very influential litigant. Justice Oka has been commended by everyone for dispensing justice with completely equal hands. Thank you, Honorable Justice Oka, for joining us in this Bar and Benches interview
Thank you.
series. So, to start off, you began your career in your father's chamber in Thane. Looking back, how much did those formative years with him shape you as a lawyer and as a judge?
See, when you practice before the trial court, I practiced almost for 2 years. That is one court where you learn basics. You learn civil procedure code, you learn law of evidence, then the procedure, then art of drafting the pleadings. The pleadings is something which is of vital importance because entire edifice is built on pleading and art of cross examination. So these are the basics which I learned, and these basics helped me throughout my career as a lawyer in the High Court and till Supreme Court, because the basic foundation uh, was very important, and the experience which I got in trial court was invaluable. And therefore, I always tell young members of the bar that if you want to practice in High Court, it is necessary for you to practice before a trial court at least for a couple of years.
So, just moving forward, judicial appointments have been seen as a give and take sort of a process in the Indian judicial landscape so far, with the latter sitting on a number of recommendations, despite having no real say in the process. Do you think it is time that the collegium took some real steps to tackle these delays? What would you suggest?
If we go by the record, now we have recommendations of the Supreme Court on the website last several years. Then we have record in the form of notifications issued by the central government appointing judges of the High Court. Invariably, you will find that there are delay of 9 months, 10 months, even there are even more than that.
Right.
So it has become order of the day. I'll tell you something interesting. On 28th of July 25, Supreme Court Collegium recommended 3 names for being appointed as judges of the Bombay High Court. Their names were cleared on 13th August 25, hardly within 2 weeks, and all 3 names were cleared. On 19th of August 25, Supreme Court Collegium approved names of 14 advocates for being appointed as judges of the Bombay High Court. Most interesting thing is, after 19th of August 25, when these 14 recommendations were made, on 25th August 25, there was a recommendation made for appointing 2 judges of the Supreme Court. On 27th August, both the recommendations, all 14 recommendations of the Bombay High Court and 2 recommendations of Supreme Court were cleared, in the sense notification was issued. In my long experience, I have seen it happening for the first time, that time gap between the date of collegium recommendation and date of actual appointment to High Court is less than 4 months. I have never seen it happening. That is number one. Number two, I have never seen Government of India clearing a list of Bombay High Court judges within span of 8 days. This has never happened. And third interesting thing is, all 14 names were cleared. This has also never happened. Some names are held back.
Right.
Now, I am part of the Bombay High Court. I am very happy that Bombay High Court got these 14 plus 3 judges very quickly. But we are discussing here issue of principles.
Right.
When 27th August, 14 names were cleared within a span of 8 days. As on that date, there are a number of other recommendations pending of other high courts for months together. In fact, one of the last recommendations of the Bombay High Court was in September 24. It took almost 8 months for the government to clear those names. And I can understand, while Bombay High Court names were cleared in a great speed, the same urgency could have been shown in respect of other recommendations which are pending as of 27th August 28.
Okay.
If this is going to become a new normal, that government clearing all names recommended by collegium, say within 8 to 10 days, it must be welcome. But if it is not normal, it is not a rule, it is by way of exception, then it's a cause of concern. Now,
Sir,
the
I
second issue, now there are limitations on collegium taking up the matter with the government. I think the simplest thing which can be done is there is a contempt petition pending filed by Bangalore Bar Association alleging breach of directions issued in 2 judgments of the larger bench. Even that petition can be taken up on the judicial side. In fact, I have flagged this issue in one of the judgments which I delivered in April. I referred to the data published on the website of the Supreme Court, and I have mentioned how there is a delay. So therefore, best thing will be to take up that contempt petition which is pending before the Supreme Court for quite some time.
Sir, I have to ask you this because there are a lot of questions which have been raised. In the recent batch of collegium recommendations that went through, there was also a candidate who is somewhat related to the present Chief Justice of India. Does those kind of recommendations getting cleared while the CJI is in office, does it raise any kind of aspersions on the independence of the judiciary?
So you are referring to which recommendation?
The court with the last name of the Bombay High Court recommendation, who is the nephew of Chief Justice of India, B.R. Gawai, has reported.
Yes, I'll make my views very clear. Firstly, if this situation arises that there's a recommendation made by a High Court of a candidate, a lawyer candidate, who has close relative as Chief Justice or member of the Supreme Court Collegium, or a consulting judge, I'll put it that way. Obviously, the judge concerned has to recuse, because we have to see other angle also. If there is a really meritorious candidate, question is whether judiciary should be deprived of him.
Right.
But then the Chief Justice in this case should have recused. I don't know whether it has recused. And then he should have expanded the collegium by adding one more senior judge. Then secondly, even the interaction should have been with the newly constituted collegium. This is legal aspect, purely legal aspect. This can be done. The other issue is of propriety, whether it should have been done. Now, as far as propriety is concerned, the concept of propriety differs from person to person. So this is the position.
Would you have allowed your nephew to take an oath of office while you were the Chief Justice of India? Presumably so.
It's a hypothetical question, but still, I can say that I would have avoided.
So the recent publication of a collegium dissent has triggered debate. We all know whom we are referring to, Justice B.V. Nagaratna's dissent. Should all collegium decisions be disclosing reasons in public? And how do we balance transparency of the process along with the privacy of the individuals who are being recommended for judgeship?
You are right. I think the answer is in your question itself, that we have to balance transparency with the privacy. No doubt about it. And part of the dissent could have been uploaded.
Right.
We don't know what are the contents of that dissent. Suppose, take a case, I'm not on this case of Justice Pancholi. Take a case where in dissent, a collegium member writes something adverse personally about the candidate.
Right.
Maybe that can be masked and relevant portion can be published. But, by publishing a resolution, we don't bring about transparency. I'm worried about something else. If one judge had strong objection, the question is whether the other collegium members debated on those objections, whether they have gone into those objections,
Right.
whether they have deliberated upon it. And then there was a conscious decision taken by 4 others that we don't agree. So this is actually real part of transparency, that if one member of the seat, so we are dealing with dissent by a sitting Supreme Court judge, and therefore there is a dissent. Of course, judgment of the Supreme Court says that decision can be taken by a majority.
Right.
If the process has to be conducted in an appropriate manner, the dissent should have been discussed threadbare. The grounds of dissent should have been gone into, and then decision could have been taken. Of course, we are groping in the dark. We don't know whether there was any detailed discussion.
Right.
But normally, my experience is that it's not a one-time process. Unofficially, the Chief Justice discusses the names with the members of the collegium, maybe with some other senior judges who come from the same High Court. And then ultimately in collegium meeting, decision is taken. But in this case, what was the decision-making process, we do not know. All that I can say is part of the dissent, without compromising on privacy of the person concerned, would have been published, because we are dealing with not only appointment of a judge of the Supreme Court, but appointment of a judge who is going to become Chief Justice of India for a pretty long time.
Yes.
Therefore, part of the dissent could have been published. And I hope that there was a very detailed discussion, debate on the views expressed by a member of the collegium. And that's the real transparency, that if somebody raises an objection, you go into that objection.
Discuss it, right?
Right.
So, just taking a short break from the questions that I'm asking on the collegium, etc. As long as I have covered you on the bench as a reporter of the Supreme Court, whenever I have seen you deal with cases, of bail, etc., I think you have had always a very even-handed approach. And it did not matter who is the litigant before you, but there are certain sections of the civil society which kind of, links ideological biases to lawyers or judges. Why I'm coming to this question is because my first question was about your father practicing in the Thane court. Now, there is a perception, or that people, there's a belief that, your father, who was a renowned lawyer, was also a member of the RSS. Why I ask this question is because the way you have dealt with cases in the Supreme Court of India, it honestly would have come as a jolt from the blue from anyone who would know this, because they always, allude a certain kind of perception um, uh, to that fraternity who sticks to that ideology or believes in that ideology. What I want to ask you is that, did it ever have any kind of influence on your judgeship, or this entire perception linking that is done by people is completely misplaced?
See, first thing, factually, I must correct you.
Yeah.
My father was alive till 2017. I became a judge in 2003. From my childhood, from the day I remember my father, I have not seen him attending RSS Shakha. That is number one.
Okay.
At highest, he may have been associated one or two trusts with which RSS may have been associated. So I don't think that anybody can say that he was member of RSS.
Okay.
At least from the age of 5 or 6 years, or maybe 7 years, I have seen whatever I remember. So firstly, that is factually incorrect. And secondly, when you are appointed as a judge, before you are appointed as a judge, I'm talking about lawyers who are elevated, you deal with various cases. Now, for example, as a lawyer, I must have appeared for almost all political parties, maybe disputes arising out of municipal election or any other dispute, election petitions. So therefore, as a lawyer, I remember to appear for all parties. Maybe for some particular leader, I may appear in number of cases. It all depends on faith litigant you have. So therefore, as a lawyer, I don't think we are concerned with any philosophy, and the kind of practice which was there in Bombay High Court and the time which we are required to devote to the work, it was impossible for at least me to do anything except practice. And when you become a judge, you are a completely different person. You take oath under the Constitution that you will abide by the, even if you don't take oath, under Article 51, it is a duty to abide by the Constitution, to uphold the ideals. So I think when you sit as a judge, you look at the case, there's a law laid down about bail. There's Article 21, which has been interpreted right from Justice Krishna Iyer, Justice Bhagwati, so many judges.
Right.
And therefore, it is your duty to uphold Article 21. Liberty is the most important thing, or freedom of speech and expression. So when you sit as a judge, ultimately it is your duty to uphold the Constitution. See, there are cases I will tell you. For example, in the case of a bail, you may feel that this is very heinous offense, but you don't get influenced by that.
Right.
Ultimately, you have to see there are parameters laid down for grant of bail, whether case is made out for or not. For example, the offense under UAPA may not be, those stringent conditions may not have been fulfilled. But if there is long incarceration and trial is not likely to start, the law is very clear. Then you must give benefit of Article 21, release him. So, frankly speaking, your personal inclinations cannot and should not, influence your role as a judge.
Absolutely.
Because I'll give you one example. Now, we consider Justice Krishna Iyer as one of our greatest judges.
Hmm.
No doubt, even his orders were criticized. His order granting stay in Prime Minister Indira Gandhi's election petition, that was criticized. But
Every.
we can't forget that he was active member in politics. He was minister in one of the cabinets in state of Kerala. And I don't think anybody has alleged any bias against him, that he belonged to a particular political philosophy and that was reflected in his judgments. So we are least concerned uh, with the personal inclinations as a lawyer. Question is whether he is a good lawyer, a sound lawyer, whether he has inclination to do work of as a judge. These are the
Right.
material considerations.
Um, so years ago, when the state accused you of bias in the noise pollution matter, you faced it directly. What should be the standard response when governments, especially allege bias against a judge?
Firstly, only because some litigant alleges bias against you, you should not recuse. In what cases judge should recuse? There are standard norms. So therefore, only because bias is alleged, one should not recuse. But in the facts of the case, when I was told in the morning that application for transfer has been moved, though I declined to recuse, I stayed my hand till afternoon because I told the lawyers that since transfer petition is pending before the Honorable Chief Justice of the Bombay High Court, we'll defer the hearing till afternoon. So this should be the approach, that after alleging bias, you are told that transfer application has been moved before the appropriate court, then you should stay your hands for a while. But only because somebody alleges bias against you, you should not recuse. Because please understand this: by alleging bias, only because bias is alleged, judges start recusing. It will be very easy thing for party to get rid of a judge.
Right.
Right. So therefore, proper approach is don't get bogged down because of allegations.
Hmm.
Only if you feel that you should recuse, then you should recuse. But only on the basis of allegation of bias, one should not recuse. See, there are
But
standard
sir,
norms of recusal.
my,
If you are
my,
dealt with the case in a particular, indirectly also you are dealt with the case, one of the parties even remotely,
hmm.
or you are not hearing a case of a lawyer who is appearing. These are the grounds for recusal.
But sir, my question was around the state bias. When the government itself alleges bias against a judge, then what should the judge do?
See, in a lighter vein, I'll tell you, in the morning, bias was alleged against me, but we heard some matters finally. In some cases, even state was the petitioner. Their lawyers appeared and argued the matters because perhaps their contention was that bias was only in relation to a particular case, not general bias.
Right.
Right.
Okay. Um, so this actually forms a very important question. Is India's judiciary truly independent? Um, what are some of the realities that we need to face, and how do we remedy them?
See, this question, whether judiciary is independent, I think this question has to be really answered by members of the bar, the litigants, and common man. See, so far as I am concerned, I can talk about me. I can't talk about others.
Absolutely.
But if there are allegations with material against somebody which indicate that there is some kind of a compromise on independence, surely that has to be dealt with in accordance with law. And I believe that lawyers or litigants, they can always make constructive criticism of a judge, but it can't be that without any basis motives are attached to a judge, because we have to really take overall picture. we live in adversarial system. One party is bound to lose. Therefore, only because somebody has lost or suffered adverse order, without any basis, such allegations should not be made, and if at all they are made, they should not be entertained.
So if you, even if, from a hypothetical ground, but if you had the power to make three changes to the way the Supreme Court functions, what would they be?
See, I'm too small to say that.
No, no, not at all, sir.
One is, I always said, even during the time when I was a judge, that there should be a fixed roster as there in the High Court. And even there should be order of the Chief Justice laying down that if there is a recusal, it will go automatically to a particular bench. That is number one. Number two, so that first thing, it rules out manual intervention by the registry.
Right.
And second reform which I'll suggest is that there should be auto listing, in the sense that if a case is ready after rectification of objections, the day all objections are rectified, it should be immediately placed, say on the 4th day or 7th day or 15th day from the date on which it is rectified, so that the lawyers don't have to go out of the way and make some efforts to get the case listed.
Absolutely.
And third is, on a day there are 50 cases before the court. I'm talking about Tuesdays, Wednesdays, and Thursdays. It is impossible to take all 50. The practice which should be followed is that cases which cannot be taken up should be assigned a date, maybe a longer date, which personally I used to do it. But it must be as a system, so that if a case does not reach on a particular day, the case gets a date and it should be listed on that date, so that litigant at least has that satisfaction that even if a case is not taken up on a particular day, it will be taken up on, it will appear on the cause list on the next day. It can't be that case is not reached and therefore there is no date given and the lawyer has to make a lot of efforts to get it listed. So these are the basic three changes, which are very simple. And these changes are only with a view to bring about transparency and help the cause of litigants.
In the context of the recent stray dogs matter, it has been debated much, talked about much. Do you think the court sometimes does more harm than good by passing impractical orders which cannot be implemented despite having the best of intentions? How does the court ensure that it does not do this?
See, I'll not comment upon this case, but
Right.
I'll give an example. Now, for example, there are rules under the Environment Protection Act. One set of rules deals with solid waste management. The rules are of 2016. Now, rules lay down what every local authority should be doing. Now, if you don't comply with those rules, then what you are doing is you are helping pollution. Pollution will be always on the rise. So ultimately, it is the function of the writ court to issue directions that those rules must be implemented. And they must be implemented in a time-bound schedule, and continuing mandamus should be exercised in such cases. Right. Now, the question sometimes crops up is when the orders of the court run contrary to the rule or a particular specific provision. Right. So I don't find fault with the courts, because if ultimately the authorities, the state, they don't implement rules. For example, in this case, the issue was of implementing ABC rules. So surely the courts can tell the authorities that please direct them to implement the rules, and court can monitor it. But of course, you are right. The court cannot, bypass a rule and direct something which is contrary to rules. Of course, as far as High Court is concerned, High Court can never do it. But Supreme Court can, in a given case, exercise power under Article 142, but which is done in very rare cases.
The Supreme Court has been a polyvocal institution since its inception. And the principle of bail is, the rule jail is an exception, has been a somewhat a constitutionally acceptable principle so far now. There are judges who have upheld the principle. There have judges who have gone against this principle on several grounds. But my question is on principles like these. Do you think it is very important for an institution to speak in one voice, or the judges of the court to speak in one voice, or there is bound to be differences always?
Now we are talking about bail. Now, as far as law relating to bail is concerned, is fairly well settled.
Right.
Bail under CRPC or bail under the statutes where there are stringent provisions like NDPS Act or
Right.
PMLA or UAPA. Right? So law is settled. And when you say this, there's no question that nobody can make departure from the settled law. Law has to be implemented. But in bail, what happens is, if you study the orders passed by the court, not only law, but factual situation has to be considered while granting bail. What are the allegations which are reflected against accused in the charge sheet? If there are antecedents or criminal record, what is the kind of criminal record?
Okay.
Merely saying that he has 10 cases will not be sufficient. Suppose in all 10 cases, out of 10 he is acquitted, in 5 other cases is on bail. So there are many factual aspects involved when you apply law to the facts. And maybe while applying the factual aspects, the approach of the court may be differing because judges are after all human beings. But as far as law is concerned, there can't be any departure. Settled law has to be applied to the facts of the case.
Now, this brings us to the end of the part 1 of the interview with Justice Abhay S Oka. Stay tuned for the part 2 of the interview where he speaks on bail, dissent by Justice B.V. Nagaratna, and much more.